for Toronto Centre.
Thank you very much, Madam Speaker. Madam Speaker, I'm very proud to be able to participate in this debate. It's an issue which is very close to my heart and to my political past and present and future, if I may put it that way. I had the great good fortune to be a member of this House when the question of the patriation of the Charter of Rights was before the House. I realize, looking around at some of the younger members in the House, that may strike them as a remarkably long time ago. But I had the opportunity to be present when the historic amendments were presented to the Patriation Bill, which advanced the cause of Aboriginal self-government by recognizing that the Constitution that was being adopted by the House could not take away from or deviate from existing treaty and other relationships between Canada's Aboriginal people and the Government of Canada. And that was moved and accepted by the House, and it became a very important feature that allowed patriation to take place. Subsequently, Madam Speaker, I became a member of the provincial legislature in Ontario, and as such was very proud to have been able to participate in discussions around very important First Nations issues that were discussed at Meech Lake and were also discussed at Charlottetown. And when I had the honour of becoming the Premier, I spent the first year of my mandate negotiating with the Aboriginal chiefs in Ontario a statement of relationship between the Government of Ontario and the nation-to-nation understanding that we were determined to reach between the Government of Ontario and the First Nations and the Aboriginal people of the province. Madam Speaker, I don't come to this debate without a certain degree of history attached to its importance. And when I listen to the comments that have been made about the bill, I wonder really where everyone has been, because the whole direction of public policy affirmed very strongly in the report of the Royal Commission, which was appointed by Prime Minister Mulroney, the whole direction has been to recognize that we need a new relationship between the First Nations people and the Government of Canada. That relationship has to be one based on a profound mutual respect. It has to be based on a different and renewed understanding of the importance of the principle of self-government and what that means and what that entails. And we have to abandon the paternalism and the frequent efforts that have been made, the paternalism that's entrenched in and seeps through and permeates the Indian Act, and we have to move beyond that to a new relationship. Madam Speaker, we've been able to do that in a number of situations and circumstances where new treaties have been signed and negotiated, but it must be said that we have not made, since the collapse of the defeat of the Charlottetown Accord, we have not been able to make the kind of progress in self-government discussions which certainly I would have hoped for and I would have argued for. Now, I want to say in all sincerity to the Parliamentary Secretary who's presented this afternoon the case for the bill and against the hoist motion which has been proposed by the Liberal Party, that I don't look upon this as a partisan issue. I really don't. I don't see this as an issue in which, as he says, he doesn't want to see it become politicized. The whole question that's being discussed here is not one that can be subject to easy formulas. So when he says, for example, that this is as a result of the government's determination to do something on behalf of the most vulnerable, it's the phrase "on behalf of" that we have to think through its implications. And everyone in this House has to understand that if we are to take government-to-government relationships seriously, it means, and I feel this very strongly as a Member of Parliament, I don't have a right to pass legislation that applies to First Nations people and on First Nations reserves unless that legislation has the full support of the people on whose behalf it is being proposed. We have to abandon the kind of paternalism that unfortunately underlies this legislation. It simply isn't possible at this time in our history for us to take this kind of approach. I know it's difficult. I know it's frustrating. I know it's costly. The parliamentary secretary spent some time focusing on how much money was involved in consulting with the First Nations people. All I can tell you is, until I have seen clear evidence that this legislation has the full support of the First Nations governments of this country, has the full support of the First Nations, those who are responsible within the First Nations community, and those who have a strong position, those people who sat across the table from me at Charlottetown, those organizations which were represented on an equal basis, sitting with us throughout the negotiations on the Charlottetown Accord. We didn't pass the Charlottetown Accord over the heads of the people who were at that table. We only passed it because it had their support. Was it difficult to do? Of course it was difficult. Et je viens d'entendre les commentaires.
I just heard the comments by the Bloc and NDP members, and I must say that quite frankly I'm a bit surprised, because I would have thought that the principle that was recognized and long recognized, to the effect that First Nations have the right to self-government, have the right to take responsibility for their own affairs in the new Canada that we are seeking to build, well, we can't say that the legislation being proposed here corresponds to that essential idea in our real Constitution, and I would say of our future as Canadians.
Madam Speaker, however well-meaning the bill may be, and however much the government may believe that it has found the answer to a problem, the simple fact of the matter is this legislation doesn't meet the fundamental test that it has the active support and approval of the people who are being affected by this legislation. And if we take self-government seriously, if we take that principle seriously, we have to recognize that the legislation should not proceed in its current form, which is why we have moved the hoist motion. I'm disappointed that my colleagues in the New Democratic Party and in the Bloc Québécois do not take the same position. I'm particularly disappointed because, knowing the history of those parties and knowing the position that they have taken on the question of self-government, knowing that it was the leader of the New Democratic Party in 1980 who moved the amendments to the Patriation Act that in fact ensured that treaty rights were recognized fully in the Constitution, knowing of the long history of Parti Québécois governments in the province of Quebec with respect to the importance of recognizing nation-to-nation relationships, and knowing the sensitivity of the Bloc Québécois to any notion of paternalism from those coming from outside determining what is right and what is wrong, well, then I'm doubly surprised. Not shocked, but surprised. Now, Madam Speaker, I don't know what the fate of the hoist motion will be. And obviously, if the bill proceeds to committee, we will do our very best. My colleague from Ottawa-Vanier made what I think was a very good proposal, which was that if the subject matter of this bill was referred to committee, we could have, in fact, a without prejudice discussion of some of the issues. Now, Madam Speaker, I want to emphasize one point. The parliamentary secretary made some comments about how people were prepared perhaps to come to the government who weren't prepared to go to other Native organizations because of the, quote, what he referred to as, quote, the politics of the situation. Well, I have here a press release dated May the 14th, which is today, in which the Native Women's Association of Canada, the Assembly of First Nations, and the AFN Women's Council united to express their opposition to the federal Bill C-8. The organizations are in agreement, I'm quoting, that Bill C-8 is a one-dimensional approach to a complex problem that does not address the real issues in the communities. And it goes on at some length to describe the reasons why they are opposed to the legislation. Not that they have concerns about it, not that they want it to go to committee, but that they have concerns about it. And I have to say to my colleagues in the New Democratic Party, I think this will be the first time, certainly in my recollection, in which that party has voted to take a position with respect to an approach to legislation that is completely contrary to the leadership and to the membership of the organizations on whose behalf the legislation is being proposed. I am, to put it mildly, Madam Speaker, surprised that that would be the position of the New Democratic Party. Be that as it may, it seems to me, Madam Speaker, that we do have a responsibility as members in this House. We do have a responsibility to take self-government seriously. That if we are going to apologize for past errors, it isn't enough to apologize for the mistakes that have been made in the past and then to say, but despite that, we're still going to go ahead and we're still going to pass legislation because we know better. And then when the parliamentary secretary says, well, the UN says we should do it, well, then I'm completely baffled. This from a government, Madam Speaker, which has refused to ratify the UN Declaration on the Rights of Indigenous People. It's a complete contradiction. I've never heard a good word about the United Nations coming from across the way with respect to any of its approaches to human rights. And on this one issue, he picks a report, some kind of report out of context and says this is what we're supposed to do. Madam Speaker, I sincerely believe that if we are to take self-government seriously, that means not simply that we consult and say, thank you very much for your point of view, but we're going to go ahead and do this anyway, but it means that we have to respond in a different way. And that is to say, we believe on this side of the House, in the Liberal Party, we believe very strongly that these measures such as this can only be taken if they have the full support and approval of those who are responsible in leadership positions in the First Nations and Aboriginal communities. Madam Speaker, I would just close with this comment. The parliamentary secretary said that some of the reason for this opposition was what he called politics. Well, if he's saying that the leadership of the AFN has some kind of agenda which doesn't allow them to support the legislation, I think he should tell us what he thinks that agenda is. Because I don't believe that it's necessarily the case that he says somebody has to provide the leadership. It can only come from the federal government. This, again, repeats the same kind of paternalist thinking that has so bedeviled the discussion about Aboriginal rights and the position of Aboriginal people in Canada. The question of Aboriginal property, the question of matrimonial property, is difficult. The first problem is there aren't enough people who have housing on native reserves. There aren't enough people who are sufficiently housed in order to be able to cope with the existing situation. The cost of going to a provincial court structure can be expensive. The cost of going to a provincial court mediation process can be expensive. That's why the government ministerial representative who put forward her proposals made it very clear, Madam Speaker, and I'm quoting from what she had to say, when she said, the viability and effectiveness of any legislative framework will also depend on necessary financial resources being made available for implementation of non-legislative measures such as programs to address land registry issues, mediation and other court-related programs, local dispute resolution mechanisms, prevention of family violence programs, a spousal loan compensation fund, and increased funding to support First Nations communities to manage their own lands. Without these kinds of supports from the federal government, matrimonial and real property protection will simply not be accessible to the vast majority of First Nation people. So, Madam Speaker, Wendy Grant John, when she made that statement, wasn't simply saying this is something that is by the way or by the side. What she's saying is, in effect, that unless the government comes forward with a full package that is effectively negotiated with those people who are being affected, that in fact what the government wants to do won't even happen. The people that the government points to as, quote, the most vulnerable will not in fact be protected. And this is an issue that has to be addressed by the government. And if I could just close with one last point, Madam Speaker, if I have the time to do so, I would say this. There are now more children being taken into custody by provincial authorities and taken off reserve and out of their families. There are now today, there's more of that happening than even at the time of the residential schools question. There is a greater crisis with respect to what is happening to families, to Aboriginal First Nations families on reserve. There's a greater crisis today than perhaps there was in the 1950s and 1960s. And I know that there's a certain point of view that would say that it's by passing this legislation that this House will in fact begin to address some of these questions. But, Madam Speaker, I don't believe that for 1 second. And neither does the leadership of the AFN, neither does the leadership of the Native Women's Association, and neither does the AFN Women's Council. And they're right. Those issues require a comprehensive discussion, negotiation, and resolution between the Government of Canada and the Native leadership with respect to those issues. Those issues right now are being, the AFN is being forced to go in front of the Human Rights Commission in order to argue that case that, in fact, there's discriminatory funding as between what's happening to families on reserves and what's happening to families off reserve. And these are questions that need to be resolved. This legislation doesn't resolve it. This legislation doesn't touch it. And to my friends in the Bloc and the NDP who say, well, let's get this legislation into committee and we'll deal with it, the answer is, no, you won't. What you're going to have to do is deal with the measures that are in front of you. What you're going to have to do is deal with the legislation which the government has presented, which has a certain approach, a certain philosophy, and a certain direction. That direction is go to the provincial courts and get your issues settled there and give the provincial courts the mandate and the mechanisms to deal with the problems that exist on reserve with respect to family breakdown and the matrimonial home. And, Madam Speaker, I don't think in the current circumstance that is going to work. It isn't going to work without a much greater degree of thought and resolution of this question than has been presented by the government. So I am in support of the hoist motion, Madam Speaker. I hope it's successful. If it is not successful, the bill will obviously go to committee because that's what the Bloc and the NDP have said they think it should do. But I say to them in all seriousness, they have to think through very carefully the implications of forcing a bill into committee against the will of the AFN, against the will of the Native Women's Association, those organizations which were in fact represented during the constitutional discussions and which were present and participated in those discussions. That's something which disturbs me a great deal. Effectively, they're breaking away from the previous pattern that was set by the governments of Canada with respect to how would we make legal changes of this dimension. We would make them not simply with the consultation, but we would make them with the active consent of the First Nations people of the country. Thank you, Madam Speaker.
Questions et commentaires.
Questions and comments?
Member for Simcoe North.
Thank you, Madam Speaker, and I thank my honourable colleague here for his intervention this afternoon. And I must say, he mentioned his contributions to the issues that Canada dealt with in respect of our charter, and there's no doubt that history will recognize that he made contributions in that regard. But, Madam Speaker, our charter also speaks to important equality protections, Section 15 and 28, that compel the country, to compel the government of the day to ensure that they hold up these important rights and protections, I might say, Madam Speaker, especially protections that would allow, as this bill does in Bill C-8, provide the same kind of rights and basic remedies for women and children on reserve. And there comes a time, notwithstanding that one must respect the consultation and respect that the leadership in First Nations communities must have a vehicle and a mechanism to evolve the laws and rules of their own, which Bill C-8 does. The government of the day must take actions to compel those equalities, and that's essential protections for the rights and protections of women and children against violence, for example. So I would ask the member, does he not believe that we should stand, notwithstanding his comments that he was so eloquent about, should we not stand in this case on the side of protecting women and children against violence and giving them the same rights and remedies as all other non-Aboriginal families right across this country?
The Honourable Member for Toronto Centre.
Madam Speaker, I don't see a word in this bill which deals with the question of family violence. There's nothing here, and I have the support. I would invite the member to have a look at the press release that came out today from the Native Women's Association of Canada, which said that Bill C-8 should be scrapped in favor of a new approach. This may include non-legislative measures such as local dispute resolution processes and community-based solutions. The urgent need for housing, counseling services, and emergency shelters on reserve must also be addressed. That's not contained in this bill. President Jacobs went on to say, and I'm quoting from her in the press release, Aboriginal women, girls, and children continue to be subjected to violence and are often forced to leave their homes and communities to be safe. Aboriginal women have consistently stated they want safe communities where they, their children, and future generations can live. Above all else, any resolution needs to ensure that this happens. Now, Madam Speaker, the reason that I quote this at length is because I think it's important. This has just come out today. I really think it's important that the government reflect on what they're hearing from the leadership of the women's movement in the Aboriginal community, in the First Nations community, is that this bill doesn't do it. And if this bill doesn't do it, my view is this bill should not be passed. And if the Native Women's Association of Canada says this bill shouldn't be passed, it should be scrapped, and we're passing this legislation on behalf of Native women, well, I have a problem. And I think we all have a problem. We have a fiduciary obligation, Madam Speaker. We can't just say, well, I think this is a good idea, so I'm going to pass it. I have to listen to the people who say, there are things you don't understand. There are unintended consequences to what you are proposing that are going to happen as a result of what you're passing that you're not aware of. So please don't do it. When they say that to me, I listen. Thank you, Madam Speaker.
Comments? The Honourable Member for Ottawa Centre.
Thank you, Madam Speaker, and I thank the member for Toronto Centre for his comments. I think there's a couple of things that need to be stated. He did lay out his background on the issue. He did state that there are issues that need to be dealt with, and this bill won't get it done. He did state that, in his view, that this is something that shouldn't go further. What I need to know from the member is that his commitment, if it does go to committee, that we actually do have, I guess, Madam Speaker, what we heard was an excellent overview of a critique of a bill that can happen in this place, can happen at committee, and is exactly what I guess many of us want to see. I know Beverly well. I don't think it's fair or smart to say if you're against our motion right now as a group, as a party, then therefore you're not with Native women, you're not with another group. I hope that's not what he's saying. So I want him to clarify that, because I think many of us who have been with Beverly and others on a regular basis on these issues clearly want to work with them. But that maybe we just disagree on how we get this done, and that if we vote against this, it's not against Native women, it's about doing it differently, and that we can do it in another way. And hopefully if we do get to committee, he will be supporting a critique and opening a space for Native women there.
Honourable Member for Toronto Centre.
Well, first of all, Madam Speaker, I was quite sincere when I said at the beginning, I don't regard this as a partisan issue, and I'm not going to attack the motivation of any other member who has a different position than I have. I fully appreciate that there are people who have very strong views with respect to individual rights, with respect to women's rights, with respect to gender issues, and see this as being fundamental to the question. I think my colleague from across the way from Simcoe, who I've known for a long time, said that we take our obligations under Section 15 and Section 28 seriously. And I can tell the honourable member, if you go back and look at the debates that took place in 1979 and 1980 and 1981, we wrestled with this question of the balances between self-government and Section 15 and Section 28. Those debates will go on long after the honourable member for Simcoe and I are long gone. They will continue, and that's a healthy thing in a constitutional democracy. My problem, and I say this to my colleague from Ottawa Centre, whose views I respect a great deal on this question and on many others. My problem is, to me, it's a question of how seriously do we take self-government? If we take it seriously, we have to listen to the people who are saying don't pass this bill. And we have to listen to the ministerial representative who said there are all kinds of ancillary questions. There are all kinds of other questions that have to be dealt with that will not be dealt with properly if the bill is passed in its current framework. And my concern is there are lots of things which are being sought by those who are critical of this bill that the bill itself doesn't address and the bill itself can't address. What those people are looking for is a broader approach and a broader commitment from the government than they're currently seeing. And I think that's the challenge that we're facing, Madam Speaker.
And comments? The honourable member for Winnipeg South.
Well, thank you, Madam Speaker. Just a quick question, of course, for the member opposite. I know he's been talking about consultation, as his other colleagues have been all day. Clearly, the Liberal Party didn't consult their opposition party members in relation to their motion. But, Mr. Speaker, Madam Speaker, as an Aboriginal person from the West, having met with many First Nations women, clearly there's a great desire to have the opportunity to be able to have matrimonial real property rights. I know that he's suggesting there needs to be unanimous consultation. We as parliamentarians, when we see something that needs to be rectified, we need to act. And so would he not agree that we as parliamentarians need to be able to extend this opportunity to First Nations women?
The honourable member for Toronto Centre.
I guess I'll try to state my view in as clear a fashion as I can, and the member is certainly fully entitled to disagree with it. I think the way I expressed it in the debate was to say this. I don't believe that this House should be passing legislation which, in my view, inherently touches on self-government and inherently touches on other Aboriginal rights with respect to property and to self-government without their consent. That's my position. My position is this House can't, as it did with the Indian Act, in the same old manner, saying, we know best, we know what has to happen, it's our, we'll do this, we'll take these steps. I don't believe we have the right to do that.
The Honourable Parliamentary Secretary for a very, very brief question. There's 1 minute left.
Thank you, Madam Speaker. I've listened with great interest, and my name was invoked many times for my position, but I guess the question I would ask of the member from Toronto Centre is there is a fiduciary obligation on the part of the government. You described the bill as being paternalistic. I believe that it's not paternalistic. I believe there's a fiduciary obligation. Would the member like to comment on that?
Honourable member for Toronto Centre has 30 seconds to respond.
I believe we have, the member and I may have a different view of what that fiduciary obligation is. I certainly believe we have a fiduciary obligation with respect to the rights of all Canadians, and I think constitutionally we obviously have a responsibility that's in the federal government with respect to First Nations and those who are described as Indians in the Indian Act. But I also believe we have a fiduciary obligation to recognize that there's an inherent right to self-government. I spent most of my political life arguing in favor of that, sometimes in situations where it was very difficult. If we are to take self-government seriously, it means we can no more pass legislation for reserves in this way.
I regret to interrupt the Honourable